So the little R symbol designates when a trademark is registered, and it's actually a criminal offence to use the little R symbol if your trademark is not yet registered in quite a few countries, including the UK and the United States, for example. And then the little TM symbol, on the other hand, shows that your trademark is unregistered, or that you're using your trademark as a trademark, but it's not yet registered, or you haven't actually applied for it as a registered right. So that can actually be used as evidence if you ever need to show that you've got a registered right.
And welcome to episode 7 of Let's Talk Pure Ideas. I'm Katia Douglas, the Commercial Director of Pure Ideas.
And I am Danni, a trademark attorney at Pure Ideas.
We're really pleased to bring to you today the part 2 of our Trademarks podcast. It has been, the part 1 was one of the most popular podcasts we've done to date. I think all the information that Danni gave was so interesting. Lots and lots of people have visited it several times. And along the way, we've been gathering some questions from people who have sort of burning questions on trademarks. And we thought it was time for Trademarks 2, so we can talk through some of those. So Danni, the first question that we get asked is, who can own a trademark?
So pretty much anyone can own a trademark. Any legal entity can own a trademark. So it can be one individual on their own. It can be a couple of individuals together. It could be a limited company or a partnership, or even charities can own a trademark.
Okay, and can you, with a trademark, can you transfer the ownership to somebody else if you need to?
Yes, you most definitely can. Yep. It's very important that if needed, that you can transfer the legal entity or the ownership of a trademark from one to another. It's what's known as an assignment, so a change of ownership. It's really important that any changes in ownership are registered at the UK IPO, so the Intellectual Property Office, for it to have effect. For example, if we ever need to raise an opposition in your name, or if we ever need to take any infringement proceedings, for example, to claim any damage in the future, touch wood, if anything were not to go wrong, for example, we need to ensure that the ownership of the trademark is in the correct name, so that the register is reflective of that.
Okay, that's really interesting. And another question that we get quite often is, what is the difference between the little R symbol, meaning registered, and TM? When could you use them, or should you use them?
This is a question I get a lot. The distinction between the two is essentially whether a trademark is registered or unregistered. So the little R symbol designates when a trademark is registered, and it's actually a criminal offence to use the little R symbol if your trademark is not yet registered in quite a few countries, including the UK and the United States, for example. And then the little TM symbol, on the other hand, shows that your trademark is unregistered, or that you're using your trademark as a trademark, but it's not yet registered, or you haven't actually applied for it as a registered right. So that can actually be used as evidence if you ever need to show that you've got a registered rights in infringement or opposition, for example. So it's actually very important that you use the correct symbol, and we've had instances of people using the wrong symbol before. So yeah, make sure you're only using the registered little R if you have a registered trademark.
So anybody out there using R when they shouldn't be, perhaps very quickly look at what you've got on your collateral and get it changed double quick. Okay. Yes. Something that came up in our last podcast was about what happens when somebody copies your trademark and or tells you you're copying their trademark. What can you do about that?
So there's quite a lot of things that we can do about it. Firstly, the level of similarity between trademarks is assessed using the oral, the visual and the conceptual similarities between both the marks, and then also the similarities between the goods and services of a mark. So a way of avoiding any potential issues is if you have a brand new mark, or you're looking at finding a new mark and you're concerned that there might be an issue out there or a conflicting previous mark, we would always recommend carrying out a a clearance search before filing to see if there's any problematic or existing trademarks that are already on file, to potentially avoid any accidental similarity occurring. Or if you, on the other hand, find that someone is using your trademark without your consent, or if they're using a mark that is confusingly similar to your own, at that point, we obviously always advise that you seek legal advice as soon as possible. If this were ever to arise, the best approach is usually to start off by sending a cease and desist letter to the alleged infringer. 9 times out of 10, this approach usually works. If the cease and desist letter doesn't work, then there are other options we can look at. For example, oppositions or infringement proceedings, if they were ever needed. Another approach that we can always do is we always recommend implementing a trademark watch. This is a service, an ongoing service, so it's a watch where we monitor trademark registers. It could be the register in the UK, or it could be registers around the world, to see if there's any identical or confusingly similar trademarks that are applied for that may be problematic to your own mark, so that it allows us to take early action as soon as possible.
There's a lot of information there, isn't there? You can see why you'd need to get advice on this sort of thing if it cropped up. I mean, I know we do a lot of cease and desist letters, and they're highly successful, and we hope for the client's benefit that it's not going to turn into an opposition, but at least they know they've got that sort of ongoing advice if it does. So in terms of the sort of trademark registrations, are there any official fees that have to be paid when you're registering a trademark?
So there are official fees that are due when filing an application. The level of fees can vary depending on where you're looking at filing your application, so the jurisdiction, and it can also vary depending on how many classes you include in your application. There's an official fee for every class, so the more classes you're looking to protect in your application, the more expensive it's going to be. There are then also official fees at renewal. So a trademark can be renewed every 10 years, in the majority of countries, and it can be renewed indefinitely, subject to the payment of renewal fees. You can also look at applying for a registered European community trademark at the EU IPO, which is a regional trademark. So there's official fees there, and it can you can have significant savings by using this route rather than applying for individual national registered trademarks, for example, in France or in Spain or in Italy as individual marks, and as well as an EU trademark. There's also a Madrid International Worldwide trademark. I say worldwide in parenthesis because you can file in up to 120 plus countries, but you need to specifically designate a specific country in this application. The more countries you designate in the application, the more expensive the application will be. And then again, for both the EU and the Madrid Worldwide application, the more classes you include in the application, the more expensive the application will be.
You mentioned some really useful stuff there. I mean, two things that occurred to me while you were talking. There was the renewal side of things, which, as you mentioned, trademarks renew every 10 years. But we also have within Pure Ideas a renewals department that deal with patents, not just trademarks, but patents and design rights as well. If you'd like any advice or help, please follow the links at the end of the podcast, and we'll be very happy to have a chat with you. One of the other things that you've touched on before, I know, is non-use of a trademark. We had this recently with a client in relation to whether they could whether they could register a trademark if there wasn't an intention to use it. What's your reaction to that, Danni? What is possible?
Yeah, so that question comes up quite a lot. So, for example, in the United Kingdom, when you are looking to file a trademark, you need to have a bona fide intention to actually use the trademark that you're applying for the goods and services that you are looking to protect. There is a period of 5 years non-use in the UK. That essentially means for the first 5 years of the mark's life, after that period of time, if you're not using your mark, your mark can then be vulnerable to cancellation action. So it can be challenged because a third party believes you're not using your mark for the goods and services that you have protected. So for the first 5 years of your life, the application or your registration at that point, cannot be challenged for non-use. After the first 5 years, it can be challenged. So basically, make sure you're using your mark for the goods and services
absolutely
that you've applied for. The non-use period also varies for different countries as well. So, for example, in the United States, it's 3 years. So depending on where you have protection, the validity and the amount of time that you have for a grace period of non-use changes. So that's something to always bear in mind as well when you're looking for protection around the world.
And this is the kind of thing that we can advise clients on, isn't it?
Yes.
So are there any other costs associated with trademark applications? We talked about what we call official costs with the intellectual property offices, but what about other costs, Danni?
So most of the costs are involved at the filing stage. So although there are other countries around the world that have official fees that are due upon registration. However, here at Pure Ideas, we are upfront about these costs, so we will let you know about them in advance and before filing. However, during filing, an application is examined. So before it is registered, it goes through a formal process at whatever intellectual property office it may be, and formal objections may arise against your trademark application. So if they do, there may be costs involved in overcoming these objections. An application is also published for third-party objections, and this is where oppositions usually occur. So if an opposition is raised, again, there'll be cost for dealing with this. Unfortunately, we don't have a crystal ball, so we don't know if any objections or oppositions will arise. But if we receive receipt of said objections or an opposition, we will let you know about them, and we will let you know about any costs that are involved and how it is best to proceed. Further on down the line as well, so once a trademark has registered, there may also be further maintenance costs involved in specific countries. Again, this is the United States. The United States has a lot of additional costs further on down the line. The US's laws, trademark laws, are very different to the UK's. So there is a maintenance requirement in the United States during the 5th and the 6th year, so the anniversary from registration, where we need to submit a declaration of use showing that the mark is still in use in United States commerce for the goods and services that you have protected it for. So again, it's one of those things where your trademark is registered for 10 years, but you need to file this declaration of use during the 5th and the 6th year to keep it in force and protected.
Right. Okay, so again, lots to consider. I mean, something that you've touched on quite a few times during our conversation today is about oppositions, and it's a whole topic area on its own. So I guess what we'd like to say is that we do plan to do a part 3 for trademarks, and that will be to cover the sort of more thorny issue of oppositions, because I think there's a lot to sort of uncover in that particular area. To end on a sort of interesting note, obviously it's all interesting, Danni, but in terms of sort of celebrity trademarks and that sort of thing that have made headlines in the past, have you got any little nuggets of information for us?
This is one of my favourite things, when celebrities try and sometimes fail to trademark certain things. One of my favourites is when Kylie Jenner infamously tried and was unsuccessful in trademarking her name Kylie. Her application was denied because it's a very common name, and Kylie Jenner is not the only famous Kylie, because of course Kylie Minogue famously opposed her application. So that's one of my favorites. Taylor Swift also made headlines a few years ago when she tried to trademark a Swiftmas around the time of year of Christmas, obviously, for sending gifts to her fans. And then another famous one that my fiance loves is Usain Bolt, who I think is still the fastest man on earth. He owns several trademarks, including a gesture mark for his widely known lightning bolt pose. So celebrities try successfully sometimes, and usually unsuccessfully sometimes, to trademark the most random things.
Yeah, it keeps our lives very interesting, doesn't it, all of that? So, Danni, thank you once again for your all your pearls of wisdom on trademarks, and for sharing your knowledge with us. If any of the listeners feel that they want to know any more about trademarks or renewals or anything else relating to intellectual property, then please do follow the links after this podcast, and we'll be very happy to have a chat with you. Thank you.
Thank you.